Good morning and welcome to the Berks County Board of Elections meeting. Today is July the 12th and it is 4 minutes after 11 and we will call the meeting to order. Do apologize that we had to start a little late, but the Board of Elections meeting.
July the 2nd.
What did I say?
12.
Oh, I'm sorry. July the 2nd. Thank you for the correction.
I didn't catch it either, so.
It's the glasses. It says here, it does say July, it's on the agenda. So we'll get started with the public comment notice, and Sylvia will be reading the notice for us today.
Public comment will be accepted in person and through the Q&A function. Please include your first name, last name, and municipality for all comments. Any comments without name and municipality will not be considered. Each citizen can submit one comment. Comment length is dictated by limitations of the platform being used, Teams Q&A. In-person comments will be accepted first, followed by comments submitted virtually. The meeting comment period is limited to a total of 30 minutes, including both in-person and virtual comments. This time period may be extended at the county's discretion. Please be concise. Comments that are germane to county business will be read during the meeting and should not be considered to be interactive dialogue. The county shall be the final arbiter of whether a comment is germane and should be read. Any response to public comment will be done at the county's discretion.
Okay, thank you very much, Sylvia. We'll move to the approval of the minutes of the June 5th, 2026 special election board meeting. Are there any additions or corrections? If none, the minutes stand approved as presented. Have any public comments on agenda items? We have one, but it is not on any agenda item, so that will be done at the end. We'll now move on to the agenda items. We have 5 items on the agenda today. And the item number 1 is voting system malfunction report approval. And this is to authorize the submission of the voting system malfunction report for the 2026 general primary to the Department of State. This is a form that's done every election and it's completed. And we did have to replace 7 express votes and 2 DS 200s. But none of this had any impact to voters. So although it did have no impact to voters, we are still reporting that to the Department of State.
I'll make a motion that we approve the malfunction report and have it sent to the Commonwealth of Pennsylvania Department of State.
Second.
We have a motion and a second. Any discussion? All those in favor signify by saying aye.
Aye.
None opposed. Motion carries. The second item is polling place accessibility survey, and this is to authorize the execution of the 2026 survey of polling place accessibility for the elderly and persons with a disability to the Department of State. And every year we have to, again, submit to the state that we have reviewed all of our 202 polling locations and that they are either ADA accessible or will have the necessary accommodations and or modifications for people with disabilities and for the elderly for each election. This has been done so, and all 202 of them are either accessible or will have the necessary accommodations or modifications.
Mr. Chairman, I'll make a motion to authorize the execution of the 2026 survey of polling place accessibility for the elderly and persons with a disability to the Department of State.
I will second that motion.
We have a motion and a second. Any discussion? If none, all in favor signify by saying aye.
Aye.
Motion carries. Item number 3 is Act 88 grant application, and this is discussion and authorization of the submission of the application for the Election Integrity Grant Program, also known as Act 88, for funds to be utilized on the November 3rd, 2026 general election and the May 18, 2027 municipal election. This grant is for a year, but instead of running the calendar year, it runs a fiscal year, which would cover the general election 1 year and the primary election the following year. And we receive about $1.3 million in this grant. We don't know what the amount will be for this year, and the application is not due until August. But Ann and her team wanted to get the authorization ready to start preparing the application for this year.
I'll make a motion to authorize the submission of the application for the Election Integrity Grant Program to the Commonwealth.
I'll second the motion.
We have a motion and a second. Any discussion? If not, all those in favor signify by saying aye.
Aye.
None opposed. The motion carries. We'll now move on to item number 4, and these two, I'm going to ask our solicitor to fill us in on these. Item number 4 is discussion of correspondence received regarding City of Reading ballot questions proposed by the Charter Review Commission.
Thank you,
Your solicitor.
Thank you, Commissioner, and good morning, Election Board. So on June 23rd and June 30th, the Board of Elections received letters from the chair of the City of Reading's Charter Review Commission. The substance of the letters pertain to the proposed 13 ballot questions proposed by the Charter Review Commission to the City of Reading. Those 13 questions were, I believe, on a City Council agenda about a week or 2 weeks ago, and they were subsequently removed by City Council from the agenda. I believe the reason stated was for a failure to conform to the requirements of the charter, the city's charter, regarding the submission of a report regarding the ballot questions to City Council. Just for a little bit of background, we were aware of these 13 proposed ballot questions. Previous drafts of the ordinances for the ballot questions were provided to Election Services and also my office for review, because it is the Board of Elections' responsibility regarding ballot questions to prepare the plain English explanations, and in this instance also the form of the ballot questions. So I previously reviewed all 13 of the proposed ballot questions with Ann, and our revisions were provided to the city and the Charter Review Commission, so that in the event there would be ordinances passed sending the ballot questions to the Board of Elections, they would be in good order on our end. The relevant law regarding these ballot questions is set forth within the Home Rule Charter and Optional Plans Law, which governs the City of Reading's Home Rule Charter. And I'll just read from it. And it states, a referendum on the question of the amendment of a Home Rule Charter or an optional plan of government shall be held when the election officials find that the initiative, petition, or in this case, the ordinance of the governing body is in proper order. The referendum is governed by the provisions of the election code, and the election officials, which would be the Board of Elections in this circumstance, shall cause the question to be submitted to the electors at the next primary, general, or municipal election occurring not less than the 13th Tuesday following the filing of the ordinance with the County Board of Elections. And it's the County Board of Elections' responsibility to frame the question to be placed upon the ballot. Here, as I stated earlier, the proposed ordinances were removed from the City Council agenda. As I understand it, they were never voted on, they were never passed by City Council, and therefore they were never formally filed with the Board of Elections, which is really the trigger, the requirement on our end for us to be able to review it for potential placement on the ballot. As I stated earlier, the deadline under the Home Rule Charter and Optional Plans Law, the deadline to submit the ordinances to us would be the 13th Tuesday prior to the election, which would be, in this case, August 4th by my calculations. But just from our end, from the Board of Elections end, our role is to review properly submitted ordinances and place it on the ballot when, quote, the election officials find the ordinance of the governing body is in proper order. We don't have the authority, nor is it our role, really to intervene regarding these ballot questions. Again, our role is really limited to the initial review of the plain English explanations and the ballot question, because that is statutorily our responsibility in this case, to ensure compliance with the election code. And then we would review them for sufficiency once a properly passed ordinance is submitted to the Board of Elections. Here, that never occurred. So again, we don't have the authority, nor is it our role to do anything further with these ballot questions at this time. Yes.
Is it true that this is unique among municipalities in Berks County because of the home rule charter and the committee that they have? You wouldn't have the conflict because normally a ballot question, if it would come from the governing body, and the governing body of other municipalities could be township commissioners, township supervisors, or a combination of mayor and council. But again, in a borough, this is the only home rule where you have a home rule committee that submits these questions to their governing body, and then the governing body is supposed, well, it's not supposed to, if they want questions on the ballot, submit to us. So it's a little more confusing than it would be with any other municipality.
Yeah, I would agree. Generally, it's fairly straightforward when we get ballot questions from municipalities. It's, formally passed by the municipality, and it would come directly to us here. Within the charter, it provides for a charter review commission, which is created. They review the charter, and then, as I understand it, they make their recommendations to city council, and then city council will review the recommendations and the proposed ballot questions for placement, or to pass the ordinances to recommend or directing us to place the question on the ballot. So there is an extra layer here via the Charter Commission and the Home Rule Charter of the City of Reading.
Because she's going to come. Okay, got it.
But in any case, Cody, the election board doesn't have the authority to essentially overrule a decision by the local governing body, whether it's a home rule or any other municipality. We don't come in and say, okay, they decided not to put something on, we're going to overrule it. We don't have that authority.
Correct.
Okay.
Other than the language.
Yeah.
The language we do.
Right.
Oh, yeah. So like if it pertains to like, we're responsible for statutorily the plain English explanations for all ballot questions. The ballot questions themselves, in this instance, we would be responsible for because the Home Rule Charter and Optional Plans Law makes that our responsibility. Other statutes, like I think the Second Class Township Code specifically dictates what specific ballot questions look like. So we don't have the authority in that instance. But you are correct. In any event, we do not have the authority to step in and just place these on the ballot without the formal statutory procedure being followed, nor would I recommend that we kind of get involved or, take those types of proactive steps. So
Thank you.
Okay, thank you.
Okay, any further discussion or questions around this? Okay, move to the next item, which is an update and discussion on recent decisions issued in election litigation matters, including decisions pertaining to the SAVE database and access to Pennsylvania's voters' rolls. And there's various items here, so again, I'll let our solicitor touch on those legal updates for us.
thank you. And you are correct. There is a good amount of litigation ongoing at the federal level regarding various issues that could potentially impact future elections. The first, as referenced on the agenda, is there was litigation regarding the current iteration of the SAVE system. And on June 22nd, the U.S. District Court for the District of Columbia issued an opinion. The case was League of Women Voters versus U.S. Department of Homeland Security. The matter pertained to recent updates to the SAVE system, and the allegations within the lawsuit was that the recent modifications to the SAVE system transformed its functionality, increased the scope of covered individuals, made the SAVE system less accurate, and violated statutory procedures and was contrary to law. And really what that all means is the main focus, the allegation was that the SAVE system aggregated sensitive personal data in a way that could result in voters being purged from the rolls who were actually entitled to vote. That was the gist of the argument of the lawsuit. On January 22nd, as I said, the District of Columbia issued an opinion. And in short, what it found is that Congress had prohibited the government from really centralizing Americans' personal identifying information in the manner that was done with the SAVE system. And it outlined various concerns about privacy rights and the threat to one's right to vote. And also it discussed a lack of compliance with the Social Security Act, the Privacy Act, and the Administrative Procedures Act. So in short, the U.S. District Court for the District of Columbia found that the SAVE system in its current iteration was contrary to the law and therefore not able to be utilized moving forward. If you recall, though, this version of the SAVE system or the SAVE system was a focal point of the most recent executive order issued on elections. So there will be a little bit of interplay here about how this decision raises questions or uncertainty about the ability to effectuate certain provisions of that executive order that pertained to the SAVE system. Again, this was just a district court ruling, so it's likely possible that it could be appealed to the circuit court. So this may not be the end of that particular litigation. In addition, as the board's aware, there was also litigation that pertains to the Department of Justice's request to Pennsylvania's voter rolls. Last Saturday, Judge Bassoon of the U.S. District Court for the Western District of Pennsylvania dismissed the DOJ's lawsuit against Pennsylvania, which in short sought a copy of Pennsylvania's unredacted voter rolls. The court found that the DOJ was not entitled to Pennsylvania's unredacted voter rolls. In short, the court pointed out that the government failed to demonstrate its entitlement to the rolls under the National Voter Registration Act, as well as HAVA, the Help America Vote Act. And there was also concerns about the request compliance with the Civil Rights Act as well. This decision will also have some interplay with the previous executive order that was issued. As the board is also aware, there was some rules proposed by the Postal Service in response to that executive order, which discussed the Postal Service and not delivering mail-in or absentee ballots from states that did not provide this voter information to the government. But what was also interesting in that regard, though, is that USPS rule that talked about prohibiting delivery of mail-in ballots and absentee ballots unless states turned over the voter roll information. There was also litigation in that regard. Yesterday, a judge from the DC District Court issued an order saying that that rule violates a 2021 legal settlement that required USPS officials to take, quote, extraordinary measures to ensure timely delivery of mail-in ballots through at least 2028. So that is just kind of a little snippet of the litigation that is going on. Again, these are mostly district court decisions, and they could be further appealed. But I thought it was important just to reference it here today, just to apprise the board that there is a good amount of federal litigation going on at the federal level, which could affect, how elections, are run. It's something that we are currently monitoring and continue to monitor, and we'll keep the board updated accordingly. And the last case I would reference is, if you recall, the Eakin v. Adams County Board of Elections case, which is the undated and incorrectly dated ballots, which started in the Western District, went to the Third Circuit, went back to the Western District, back to the Third Circuit, and is now pending a writ of certiorari before the U.S. Supreme Court. The U.S. Supreme Court did not formally accept certiorari in that case, but they did permit certain amicus briefing to occur, and they also asked the United States, the federal government, to weigh in on their position in the matter, which seems to signal that the U.S. Supreme Court is considering granting certiorari and hearing that matter, which is also something that we will keep the board apprised of. So a lot going on out there in the terms of litigation, and we will keep you updated accordingly.
Okay, thank you, Cody. A lot of things that could still have an impact on the November
I
elections.
just have a question on another legal, I'm trying to remember. I think it was a U.S. Supreme Court decision. This has to do with accepting mail-in ballots after Election Day. There was a Mississippi law that allowed the acceptance of mail-in ballots as long as they were postmarked by Election Day. I think it gave them like a week or something like that. And there was a case, I guess, filed against that to try to stop it. And they threw that out. They said that they could. Am I correct? My question is, I think, again, a lot of legal stuff. I'm becoming a part-time attorney here. Our state Supreme Court ruled that the write-in ballots had to be received by Election Day. Would that the U.S. Supreme Court affect that ruling or not?
So you are right. That decision was issued this week by the U.S. Supreme Court. As I understand it, I believe the laws in the states that were affected permitted mail-in ballots to be accepted up to a certain amount of time after Election Day, provided they were timely postmarked. Pennsylvania law requires that we can only count mail-in and absentee ballots received up to 8 p.m. on Election Day, with the exception of like military overseas and things like that. So I don't read that Pennsylvania or the U.S. Supreme Court case that was issued this week to affect Pennsylvania, unless Pennsylvania would change its law to allow for
require legislative change.
The only time that we were ever able to accept mail-in or absentee ballots after Election Day
2020
was my very first
General
election in
COVID.
2020. Due to the circumstances, the PA Supreme Court issued a decision that said we can count it up to X amount of days as long as it was timely
It was
postmarked.
5 p.m. on Friday.
Yeah.
And I don't even think it had to be postmarked. It had to be received by 5 p.m. Friday. The postmark didn't come into
If
play.
there was if I remember, if there was an illegible or no postmarked, it was to be assumed to be timely
Right,
postmarked. If I
timely,
remember
as long as it
correctly.
was received.
Yeah.
Thank you, Cody.
Okay, thank you very much, Cody. Right, well,
That
now
did
move.
clear up a lot. I just want to let you know, I'm crystal clear on everything going on.
As you should be.
legal.
Yeah, there's no other questions out there.
Okay, we'll now move to the election director's report. Ann.
Thank you. Good morning. I only have one item. Our office has begun our annual list maintenance program. So we've sent notices out to voters who have potentially moved, and we will record those responses or lack of responses throughout the summer. The program will be closed in early August, August 5th. That's all I have.
Okay, thank you, Ann. We'll now move on to general comments from the board regarding current election-related issues. Any comments? None? Okay. We'll now move to public comment. We will start with in person and then online, if any. We do have one in person, and that is Zelda Yoder. Zelda, if you want to stand up, state your full name, municipality, and you have 3 minutes, and Sylvia will be taking the time.
Hi, Zelda Yoder, City of Reading. Happy 4th of July as we celebrate our 250th. We're celebrating our founding document, which of course begins with "We the People." Our democracy depends on its people participating in their own government, most importantly by voting for their leaders. This board and our Election Services Department has always been impressive in its integrity and its respect for fairness. I'm here often and see you do that each time you meet. But as we just went through with the legal information, when there are statements in congressional hearings about not delivering mail ballots to states that don't turn over voter rolls, when there are court cases and random conspiracies relating to voting discussed in the media, people begin to wonder if their vote is secure. You should feel insulted by that because I know the work you do to keep us secure. A recent statement by a top presidential advisor said, "Change the voters, change the country." That should terrify all of us. Voter suppression is real, and we need to increase voter participation, not reduce it. So I'm here this morning to again ask that we create more drop boxes. I know it's difficult. Many voters, Berks County Democratic Committee hears from them all the time, are very concerned and increasingly so about their mail ballots being delivered on time and being counted. Timing can be an issue. The change in the postal service where the postmark is not given when you drop your letter off, but rather the first place now that it's being sorted, which I assume is Harrisburg for us, can create a delay and may lead to somebody's vote being disqualified. You have no control over the federal government, specifically the post office, but we do have control over our local voting process. Bucks County has 9 drop boxes. Chester has 13. Montgomery has 20. Lehigh has 5. They're in libraries and in some cases MDJ offices. We recently went from 2 to 3, which was a good improvement. We can do better. This is a big county. Many voters seem to appreciate the ability to drop their ballot in these boxes instead of relying on the Postal Service. Voter skepticism of the federal post office and related mail-in ballot issues is growing. In my opinion, that's being done purposefully. But in any case, voters want a safe option. So please, I know it's a staffing thing and whatever, but please look into it and consider adding drop boxes for these important elections coming up. Thank you.
Okay, thank you very much, Zelda. We do not have any other in-person. We do not have anything online either, so that will conclude the public comment portion. With that, I will accept the motion to adjourn.
So moved. Second.
The meeting is adjourned. Thank you.